Can a J-1 or J-2 visa holder become an EB-5 investor to avoid the 2-year home country physical presence requirement? Becoming an EB-5 investor does not nullify the 2-year home country physical presence requirement of a J-1 or J-2 visa. The Exchange Visitor Program requires participants to return to their home country for at least 2 years upon completion of the program. If a J-1 or J-2 visa holder cannot fulfill this requirement, they must apply and receive approval of a waiver, Form I-612, before being able to apply for another visa, such as the EB-5 visa. Without receiving approval for a waiver, a J-1 or J-2 visa holder will not be eligible to adjust status to conditional permanent resident by becoming an EB-5 investor. However, for J-1 and J-2 visa holders who successfully acquire a waiver or fulfill the 2-year home country physical presence requirement, becoming an EB-5 investor is certainly possible. The first step is to hire an experienced immigrant attorney to help navigate the complexities of the EB-5 process. Conduct due diligence to identify suitable projects, and select a project with minimal financial and immigration risk. After selecting a promising project to invest in, the EB-5 investor and their attorney can begin gathering the necessary documentation to file Form I-526E. This petition will be adjudicated by United States Citizenship and Immigration Services, USCIS, based on a number of elements, including compliance with EB-5 regulations and proof that the minimum investment amount will be used to generate employment within an eligible new commercial enterprise, NCE. A successful I-526E petition will result in a 2-year conditional residency period. Upon completion of this period, the EB-5 investor can file Form I-829 for permanent resident status. USCIS will assess the I-829 petition based on a number of elements, including evidence that the investment has contributed towards the creation of at least 10 full-time jobs, and proof that the investment has remained at risk and EB-5 compliant.